Bouygues E&S Contracting UK.
Yes, Mr. Gowdy. Just one moment. I seem to have. Oh no! I thought I'd come without my pen, without a proper pen, but I have found them.
My lord, I did succeed in coming out without my pen, so I borrowed one from one of my juniors.
That's what they're for, I believe. That's why you have two. Yes, Mr. Gowdy.
My lords and my lady, I appear for the appellant, Mr. Melki, who sits behind me. I appear with my learned friends, Oliver Mills and George Spence Jones. Our learned friend, Colm Kelly, appears for the respondent employer, as he has done throughout. The appeal, as your lordships and my lady will have seen, is with permission from Lady Justice Elisabeth Laing on the 28th of August 2024, tab 12 of the Core Bundle, from a judgment of the Employment Appeals Tribunal on the 13th of March of 2024.
It's taken a very long time, hasn't it? Sorry? It's taken a very long time.
Yes, at various stages.
Well, the worst stage, but it's all in front of the bridge now, is almost a year before it got to the registrar. Isn't that right?
Yeah, certainly there were delays in the AT administration.
Yes. Well, there we are. But it's rather a sorry story. But
none of the delays are in any way attributable, however, to Mr. Melki.
No, I see that.
That is the important point in that respect. But we're now, of course, just over a year from the EAT decision. And as the court knows, that relates to Mr. Melki's application to extend his time to present his notice of appeal from an employment tribunal decision that dismissed his direct race discrimination and harassment claims. And Mr. Melki appeared as a litigant in person at first instance. And while still in person, he presented his notice of appeal to the AT. He duly included with it the ET judgment and their reasons, and core documents in the ET, including the ET1 and the ET3. However, he omitted to include, in addition to the ET3, the respondent's grounds of resistance. That was an error. It was the sole error. And that was on the 22nd, 23rd of May of 2022. He learned of his error on the 30th of that May of 2022, and immediately corrected the error. In other words, he was all of 6 days out of time. That is all. That is when the error was rectified. As I say, he applied to extend time. That was refused, and the refusal was upheld on appeal. The main issue in the AT was whether a change in the rules that occurred applied, notwithstanding that the case had started under the rules before they were amended.
Yes.
And on that point, the AT was in Mr. Melki's favour, which enabled him, therefore, to rely on the new Rule 37, Sub-Rule 5. But he nonetheless lost, because it was said in relation to Rule 37.5, which he had established was applicable, his omission was not regarded as a minor error. So that's what it was all about at that stage, because the lie of the land then for somebody in his position on Rule 37.1, with a number of first instance decisions,
had a very uphill
was not at all encouraging. That landscape changed dramatically with the decision of this court in the Ridley case. That therefore enables us to approach the case in two ways. One is to say we should succeed under 37.5 because this was a minor error. And secondly, that in any event, we can succeed under Rule 37.
Very odd.
Wow.
It'd be very odd if you failed under 37.5 and yet succeeded under 37.1.
Well, I can
There we
see.
are.
I can see the force of that certainly up to a point. And our main point remains that we
Yes.
should succeed under 37.5. But I do have as an alternative 37.1. But for future reference, the difference between 37.1 as interpreted in Ridley and 37.5 properly interpreted may be of little practical consequence.
Yes. Is this the formal position that you need permission to amend, which I don't think has been given yet, as it was adjourned to today? Oh, you'll know, or my lady will know. I'm sorry, I didn't pick up. Have you got permission to run the 37.1 point?
Well, Junior is nodding.
He is nodding, and he
Okay,
usually
well that's
runs.
fine.
Yeah.
Yep, right. Okay, well off you go. I mean, even with those 2 points, it's a very narrow point.
Yes,
Yeah.
it's short point of construction, and the court no doubt has seen the relevant rules.
Yes.
There are 3 of them. Rule 3.
Well, we have seen the relevant rules, but we weren't given them all because 37.1 is quite important.
Yes, your lordship, the court should have in the authorities bundle the whole of Rule 37
Oh
with 1 and 5, but if not,
no, we got 37.1 as it stands.
it may be that the most convenient course.
No, sorry, exactly, but I was a slip of the tongue. I didn't mean 37.1. I meant 3.1. We haven't
Yes.
got 3.1.
No, you haven't. Where you will find Rule 3, and indeed also Rule 37, is in our skeleton. Rule 3 specifically at paragraph 32, and Rule 37, 1 and 5 at
So in the end, I
following
found
paragraph.
them, but
the-
just you said we got the rules. 3.1 is actually.
I mean,
moderately
the rule
important.
changes happened at the same time. It was a 2023 statutory instrument. It came into force on the 30th of September. And so far as Rule 3 is concerned, it omitted part of the existing Rule 3 to remove the requirement to lodge
The pleadings.
the ET1 and the ET3. But that requirement had applied when Mr. Melki had
Right.
appealed, and he had provided both those
Yes.
documents and indeed everything else except for one missing document that was very rapidly thereafter produced. So that's the context, namely Rule 3, and then Rule 37, which is at the heart of the matter. And our primary case, in essence, is indeed short and simple. It is that Rule 37.5 indicates that the magnitude of an error should be determined by the degree to which there has been compliance with Rule 3.1. That is the wording of Rule 37.5. That addresses the mischief that a rule change was introduced to address following consultation. Rule 3, of course, serves a purpose, but that is the beginning, not the end of the story. If there is not the fullest compliance with all the requirements of Rule 3, then there may be a dispensation under Rule 37. That is the structure. Either Rule 37.1 or Rule 37.5 in the case of a minor error, notwithstanding that it is an error in relation to a requirement that has a purpose, precisely because as an error it is only minor, and once rectified as here, may be of no practical consequence. And there is, as this court said in Ridley, paragraph 144 in fact, a legally significant difference between the case of an appellant, such as Mr. Melki, who lodged both a notice of appeal and nearly all the documents required by Rule 3.1 inside the time limit, as he did, and an appellant, very much not the present case, who lodges nothing at all until after the time limit has expired. The
Can I just
difference,
make one small point? You say a notice of appeal and the documents required by Rule 3.1. The notice of appeal is one of the documents required by 3.1.
yes,
And I had to look at that because at first I thought that the structure was you must lodge a notice of appeal, as it were, and you must lodge the following documents, because nearly all the cases are about the following documents.
yes,
But in fact, 37.5 would be engaged by a failure to lodge a notice of appeal. You might, of course, you'd have to be something, otherwise there wouldn't be a case. But you might have lodged just a letter or lodge all the documents but leave out the notice of appeal.
and of
So
course
structurally, the notice of appeal is one of the documents that has to be lodged.
yes, and of course, if the notice of appeal was not lodged, then it might be very difficult to say that that was a minor error in the case
I
of
was trying
that
to think of a
particular
paradigm
document.
of a major error.
Yeah.
That would be it.
Yes, indeed. And one can think of other examples of what may be major errors, as well as other examples of what might be minor errors.
Give us another example of a major error.
Doesn't readily come to
Well,
come to mind.
yeah, I suppose the next most important document after the notice of appeal is probably the judgment below.
Yes, and the reasons for that judgment.
Yeah, I'm sorry. Yes, you're
Yeah.
quite right. It's an important distinction, but
Yeah.
I really meant the
I
reason.
mean, that is a crucial document.
Yes. But
That's
even
not to say, of course, that they ought not all to be eventually provided.
oh yes, but just imagine a situation where that is left out, all of it's left out, all of the judgment and reasons. Does that mean that the jurisdiction under 37.5 is not engaged at all, even if it is then supplied promptly thereafter?
I don't know that it excludes the section 37.5 jurisdiction as distinct from very much going to what the outcome will be.
No, but the way 37.5 is structured is the first thing there has to be, I mean, it may just be loose drafting, but if you take it strictly, the first question you ask is there a minor error?
Yes.
And if there isn't, you don't go any further. And then you ask, well, has it been rectified? Then, and then, if it is minor and it has been rectified, then you exercise the discretion with a steer as to the relevant factors. So it clearly envisages that there is a threshold of a minor error after which, however quickly you rectify it and however little anyone is prejudiced, you can't succeed under 37.5, and maybe you can't succeed under 37.1 either, because 37.5 might be thought to be as it were a complete code for omissions. But anyway, there we are.
Yes. But so far as 37.5 is concerned, of course, it's necessary that any error should have been minor, but that's a sufficient basis for 37.5 potentially being applicable.
Yes.
But there are other conditions that need to be satisfied
Yes.
before you will be able to extend time.
Well, there's two conditions, aren't there? That it's minor and that it's been rectified. Then after that, it's a discretion.
Yes.
Yes.
Where obviously prejudice will be an important element.
Yes, though it's hard to see how if it is minor and it has been rectified quickly, it's hard to see what prejudice there will ever be. But
Exactly.
but still, that's. I mean, there are some oddities. It seems to me, reading how 37.5 has been put together. But you would say, on the facts of your case, we really don't need to bother about those because this is a classic minor error.
Yes.
Was rectified quickly, no prejudice.
Yes, exactly. That's the case in a nutshell. There was substantial compliance, and the EAT has only come to a contrary conclusion by imposing what we would submit as an impermissible gloss on the rule, a criterion of the significance of the error for the progression of the appeal.
Yes.
Whereas if the error has been rectified, then there's not going to be any problem so far as the progression of the appeal is concerned. So in our submission, that is plainly wrong. And indeed, Ridley, although a case on 37.1, is instructive on the basic approach under Rule 37.1 and or 5. But on under 37.5, what one is concerned about is minor, and minor in the immediate context of error. Of course, the concept of minor error presupposes, as we acknowledge, that not all errors are minor, but obviously some are. And simply to point to something being an error does not therefore begin to assist with whether the error is in a major key or in a minor key. To err, as Alexander Pope famously said, is human. To forgive is either divine or within the jurisdiction of His Majesty's judges, if there's any difference between the two.
Yes.
So what about minor? And the most obvious point is that it is a very ordinary and familiar English word. We all know what minor means. It means comparatively unimportant, comparatively small, as simple and straightforward as that. One need hardly say much more, which of course will not prevent me from endeavouring to do so.
Say etymologically, it is a comparative adjective because it comes from the Latin. But it's probably a bit confusing.
Indeed. I propose to go backwards because of course the proceedings have taken. So first Rule 37.5, ground 1, and in conjunction with that, minor error. And then finally, ground 3, Rule 37.1, in the light of Ridley. So I start with Rule 37. Which is a short point of construction. The parties do not disagree about the principles of statutory interpretation that will be well known to the court. So ground 1 is about their application in determining the meaning of minor error in Rule 37.5. And our essential point, as I have indicated under ground 1, is that the EAT's construction of minor error is far too narrow. The construction that a minor error is an error that was negligible or of no real importance to the proper progress of an appeal. So we intend to do 3 things in our submissions under ground 1. First, go back to the provision and make 2 observations about its language. Secondly, to set out why we say the EAT erred in its judgment. And third, to set out our submissions on what we say the correct approach is. The rule, as the court is aware, the structure of it refers to minor error and then to rectification, and then for extension of time, if both those conditions are satisfied, if as an exercise of discretion in all the circumstances, the error has been rectified and having regard to any prejudice there might be to the respondent. So the 2 observations we respectfully make about the provision are first that there are 3 requirements, certainly 2, but we would accept that there are 3 requirements that have to be met before the Rule 37.5 power can be exercised. First, the error must be minor, the minor error requirement. Second, the error must be rectified, the rectification requirement. And thirdly, what one might call the justice requirement, it must be just to extend time, having regard to all the circumstances, including the manner in which and the timeliness with which the error has been rectified, and any prejudice to any Respondent.
I may just be quibbling, but as I already have an observation to you, I don't really regard that as, in a sense, there's three stages, but the first two are requirements, in the sense they're absolute conditions. The third, although you may say, well, the third requirement is that it's just, but that's effectively just saying that it's an exercise of discretion.
Yes.
Yeah. Okay.
And the rule obviously must be interpreted as a whole. And in our submission, the second requirement, namely rectification, and the third element, namely the justice element, in our submission shed light on the meaning of the first, namely the minor error requirement. Secondly, the description of the error is of significance because Rule 37.5 refers to a minor error, quote, in complying with the requirement under Rule 3.1 to submit relevant documents to the appeal tribunal. And
I mean,
so
it is an oddity, isn't it? In fact, that the draftsman will have thought that meant under the new 37.1 introduced on the same, as part of the same rule change. But it's an oddity of this case that it's actually a reference to a different 3.1.
yes,
but there we are.
The previous 3.1, though the change in Rule 3.1 is of no significance for present purposes, and very often will not be, particularly since it actually reduces the requirement as to what must be submitted. But
if you look at the amendments as a whole, the removal of the requirements to submit the ET3 might cast light on what a minor error is, but maybe not.
Be that as it may, what the rule is explicit about is that the error is an error in submitting the relevant documents to the appeal tribunal. That is the document set out in Rule 3.1 as it is at any relevant stage. And we know what those are and the extent to which they were indeed, with one short-lived exception,
have we got a list
response
of what they are now?
It's the old 3.1 with little b.
Little b. That's the only change, is it?
I believe so. Yeah.
Oh, right. So, for example, things that you do still have to do is if you've made an application for a reconsideration, you have to put that in. That's still one of the requirements, is it?
I believe so. Yeah.
I see. Okay, thank you.
But of course, the position is a little complicated because there are some items which may consist of more than one document. So you may, for example, have the ET1 form and a separate particulars or grounds of claim. And a response will often consist of two documents, the ET3 and a separate ground of resistance. Now, that the claim and response can be made up of two documents, obviously something with which employment lawyers are very familiar, but it's not something that leaps at one from the language of Rule 3.1b itself. It's also not clear from the leaflet parties are sent notifying them how to appeal. But it is explained in the relevant practice direction in force at the time. So we acknowledge that there was, we would say, very understandable error, and that's relevant in considering whether or not it is a minor error. And in the EAT's judgment...
Well, okay, that's an interesting point. So culpability, perhaps that's too strong a word, but the excusability of the error, you say is relevant to whether it's minor, rather than something that comes in at the discretionary stage.
Well, it certainly does come in at the discretionary stage if it doesn't come in earlier. And I submit that there is a minor error whether or not excusability is relevant. But I do say that in determining whether something is or is not minor, its excusability or otherwise is capable of being a relevant factor. Not
I mean,
necessarily
the
a
facts of
decisive
Joe
one.
Couster are quite an example of that. What they put in the employment judgment's reasons, the employment tribunal's reasons, what most people would loosely think of as the judgment,
Yes.
but they didn't lodge the order, which actually technically is the judgment under the rules, because there was some particular reason why the two had been separated. And I said, and the Court of Appeal to Gritted Teeth upheld me, effectively that was an exceptional circumstance, different test then. But basically what I'm saying is it was very excusable. It was A minor and B inexcusable. So you would say it's excusable. So you would say that excusability is a fact, comes into whether it's minor.
It's capable of doing so,
That's
yes,
it.
as a factor.
I think his lordship might have used the word venial to describe.
I might have, mightn't I? One of my
did,
favourite
yes,
words.
you did.
Yeah, I think
That's right. I remember now. You used it.
Okay, well, it's a word I'm fond of. So
I had to look it up
Ah,
during Ridley.
well, it's different from venal.
It is different from Venus.
very different.
It is different, but it required a minute or two of my time when we were doing Ridley, Mr. Cowley.
Yes, I see. Okay, well, that again. I don't think that really. It's certainly not central to your submission
No.
that this was an excusable error. Although I see why you say it was. Frankly, it's going to happen pretty often with lay people that where you have the ET3, what might be the ET1, which is very common practice, the grounds set out in an attachment. It's very easy to see how you think, oh, well, I've done the right thing. I've put in the ET3 and not notice that the grounds are a separate document. And loosely speaking, it's, I suppose, it's wrong, but it's pretty venial.
Yeah, I cannot say that it's not an error.
Yeah, of course not. No, no.
But on the
Otherwise it
crucial
wouldn't be there.
question of whether the error is a minor error, I do submit that.
Anyway, I don't want to hold up your submissions too much, but we may not choose to go a bit more broadly than the facts of this particular case.
Oh, yeah.
So that we may or may not want to express a view as to whether the concept of minor goes only your primary point to, as it were, the degree of compliance, or also includes concepts of culpability.
Yes.
Is it part of your case that in analysing this, it should be borne in mind that a significant proportion of these cases are run by litigants in person rather than represented parties? So in deciding what is a minor error or not, one has to bear that in mind. And this is a relevant elephant trap, isn't it, for litigants?
Yes. Yes.
Unwary litigants in person.
Certainly. And what may be excusable on the part of a litigant in person may not be as high a threshold in terms of whether an error is major as in the case of somebody who is represented.
I'm not sure Mr. Justice Burton would have agreed with that analysis.
But also, the general thrust of the case is that litigants in person should be held to roughly the same standards as.
In general, but not a proposition to be taken too far, I suggest.
Well, just in case you want to comment on this, my instinct is that given there's a discretion to be exercised afterwards, the neater and cleaner approach to minor is simply to adopt what you really say in your skeleton, which is the degree of non-compliance.
Yes.
And leave questions of excusability, which are slightly fuzzier, to be gone into at the discretionary stage.
I see, my lord, your lordship has my submissions on that,
Yes.
and I don't resolve from, but nor do I wish to take up further time pressing the excusability point.
Fine. But I
It's
just
very
want to
subsidiary.
give you the chance.
Yeah.
Mr. Kelly may want to say something about it. So.
Yeah. Lord, the judgment of the Employment Appeal Tribunal is at tab 6 in the authorities, and the relevant section begins at, under the heading, was the error minor, at paragraph 33. And really begins from paragraph 35 and runs through to paragraph 39 before the conclusion on minor error. And one sees at paragraph 35 that the EAT says that Rule 37.5 is designed to forgive errors which are negligible or of no real importance to the proper progress of an appeal. And it's those latter words, of no real importance to the proper progress of an appeal, which we say are irrelevant when determining whether or not an error is minor.
What about negligible? Is negligible the same as minor?
Certainly, if something can fairly be described as negligible, then in our submission that would be minor. But it may be that something can be a little bit more than negligible, but still be minor.
And negligible, if you start analysing it verbally, is or etymologically, is to do with something you can ignore.
That's what it is. Ignorable.
Whereas minor is something that you may or may not be able
Yes,
to
I
ignore.
mean, what this illustrates is the statute has chosen a word, and although we all love adding words or glossing it, that can nearly always leads to complication.
Yeah.
Stick to minor.
Yeah.
Or stick to the whole phrase.
Yeah.
Minor non-compliance, whatever it is. Yes.
And minor in the context of the three limbs of Rule 37.5, because the purpose to which the AT refer in paragraph 35 of their judgment doesn't have to be achieved by the minor error requirement alone. If an error is in not submitting a relevant document may have importance for the proper progress of the appeal, but if the error is quickly rectified in circumstances where no injustice is done to the respondent, then the error will be of no real importance to the proper progress of the appeal. And the EAT's error in our submission is in slipping from considering the purpose or design of the rule as a whole, and then using that purpose as being synonymous with the test for one part only of the rule, namely whether or not an error is a minor error. And one can see that conflation by the EAT of the purpose of a rule, of the rule as a whole, with the meaning of minor error in paragraph 36 of the EAT judgment, and in particular the last sentence of paragraph 36 with its reference to the real importance to the proper progress of the appeal. That is very much in the context we submit of rectification. And then I mean, if something is irrelevant, then obviously failure to submit it is highly likely to be a minor error. But minor error must go more broadly than simply an error in not providing a document which is not a relevant document. So there's an element of
especially now that B has come out, almost everything in 37 is relevant. In 37.1 is relevant, isn't it? Things you're required to put in are all relevant, and they're all necessary to the proper progress of the appeal.
yes, prima facie, certainly, at least that's the case.
I suppose bits of them might be irrelevant. Yes, but this will most often be used, though not in this case, where parts of a document have been
Yes,
omitted. And I
exactly.
suppose there you could have a situation where the grounds of appeal had been put in, but they'd missed out a page dealing with a point that was no longer live anyway.
Yeah.
Yes, okay, sorry. I'm making it oversimple. Thank you.
And then the EAT continues at paragraph 37, and then at paragraph 38, referring to earlier authorities, the distinction is drawn between a document and part of a document, not this case, but a feature of a number of the case. And
Well, you could say this is a part case because the grounds of resistance were part of the ET3.
yes, that would be one way of looking at it, certainly. And then at 39, unlikely to be a minor error to omit the whole document or a substantial or important part of the document, unless there are circumstances in which it can be said that the document is irrelevant to the appeal. So we're back to, if it's irrelevant, then it may be minor, but if it's relevant, then it isn't minor. And that in our submission is a complete non sequitur.
Well, 37.5, a minor error only applies to a failure to submit relevant documents. So if a document is irrelevant,
that is the nature of the error.
Is that it's not relevant? It's prescribed documents, whether relevant or not, isn't it?
well, I'm just sorry. I'm looking at 5.
Oh, I see. Yes, I hadn't picked up the word relevant. I mean, it is tiresome. We haven't got through the whole 3.1 here. Where have we got?
Is it in Ridley?
You say we've got it in your studies.
Yes, but I need to remind myself whether that is.
Well, I've had a look. You haven't got the whole of it, but you may have the introductory words.
At what point?
Will it be cited in one of the authorities? Perhaps this is Justice Edie's.
Yes,
Okay.
there were a number of cases before Mrs. Justice Edie when she was president of the.
I can't believe that relevant. In 37.5. Relevant surely must just mean the documents with the appropriate documents under 37.1. That's all relevant means.
37.1.
Sorry, I keep 37.1. I mean 3.1.
Yes.
Because
descriptive of the requirement imposed by
yes,
31.
I'm sure that's all relevant means. Yeah, for example, one of the ones which you tell me, although we haven't got the whole, survives, is where there's been an application for reconsideration. Suppose there hasn't been an application for reconsideration. You will not have to supply that because it won't be a relevant document in your case. I thought that's all relevant means, surely.
But then, if there is an error in not submitting a document that has some relevance rather than none, in our submission, the question arises whether or not the particular error in the particular circumstances of the particular case is or is not a minor
Absolutely,
error.
and the point I'm making is a purely neutral one, so we can understand. I agree, the question still remains, it's not a point against you. I'm bound to say, I would have thought that all the documents applicable in your case under 3.1 are relevant, but the question is whether the omission of them is minor.
And
I started this hair running, Mr. Daddy. I hope it's not an irrelevant hair because I was drawn to what you were taking as to paragraph 39 of the judgment,
yes,
in which the judge said, may amount to minor error to one incorporated document. That is unlikely to be a minor, but it is unlikely to be a minor error to omit the whole document. or substantial or important part of the document, unless there are circumstances in which it can be said that the document is irrelevant to the appeal. So that's why I alighted upon relevance. So the judge was using relevant in a different respect, wasn't he? There was he?
Yeah.
We've got the whole of 3.1 as it then stood in Ridley.
Yeah. Is it the
At
same?
para 12, page 83 in the bundle. And it is a notice of appeal, or false, B, the pleadings, I call them the pleadings, but the claimant response, or an explanation as to why they're not included. C, the judgment and the reasons. And then D is to do with appeals from the CAC. So that would be irrelevant in the case of, that would be an example of an irrelevant document in the case of an appeal from the ET. E is the E reflects the E is in a sense the same as C, only it reflects the distinction between a judgment of the Employment Tribunal and an order of the Employment Tribunal, because interlocutory orders are not always judgments.
Yeah.
Are not judgments. And F is an appeal from the certification officer. Yes. Well, there you are.
Yeah.
And the only you've told me, I hope this is correct, that the only one that went is B.
That's right.
Okay. Thank you.
So, my lord, having looked at the EAT, the material part of the EAT's judgment, we make 5 brief criticisms of the EAT's judgment. First, as I've indicated, that the EAT conflates the purpose of 37.5 as a whole with the purpose by reference to which minor must be interpreted. That's the first criticism. The second criticism is that the EAT's interpretation of the expression minor error is too narrow because its intention with the explicit words of Rule 37.5. Third, Rule 37.5 was introduced to change the law, and the EAT's narrow construction would mean that there would effectively be no change, notwithstanding that they recognise, as one must, that the rule change and the introduction of Rule 37.5 was precisely in order to relax the position in missing document cases. The fourth criticism of the EAT's narrow interpretation of Rule 37.5 is that it renders the rectification requirement OTOs. There will be simply no need to rectify an error that is negligible or irrelevant to the appeal. It is the fact that an error in submitting an accompanying document will often make it difficult to understand an appeal fully that requires that the error be rectified. And we say that that is the position in that respect. And fifth, and these points, of course, obviously to some extent overlap, the EAT's narrow interpretation of Rule 37.5 would render the justification element, the third element, largely redundant, because an irrelevant or negligible error is not going to cause a prejudice to a respondent as a factor to be taken into account in deciding whether or not it would be just in all the circumstances to extend time. So, my lord, those are our criticisms of the EAT. As to what we say is the right approach, we note that the proposal that time could be extended was not applied to any error, provided the error had been rectified and it was just to do so. That's not the choice that was made. And the purpose of the minor requirement is that it promotes substantial compliance with the rules, whilst allowing flexibility where there has not been absolute compliance. And we submit that this is a case where there was substantial but not absolute compliance, and where the rules with their reference to minor error do allow flexibility, which enables the tribunal, and which in this case should have led the tribunal, to say that there was a minor error which had been rectified, and that it was just to extend time. That the test, as I say, relates to how substantially the 3(1) requirement has been complied with, and here it was substantially, albeit not absolutely entirely, complied with. So we say, whether one's looking at 37(1) or 30, as in Ridley, or 37(5), that this court's approach in Ridley, as para 114, is eminently sensible. That is to look at both the degree of compliance, but also at the importance of the omitted document when considering whether there is minor error. Our submission relates to the degree of compliance and the importance of the element of non-compliance.
I wonder whether the importance really comes into it, does it? I mean,
but importance comes into it to this extent, that in terms of whether or not there is a minor error, one is looking to consider as a factor the importance or otherwise of the document for instituting an appeal,
well,
rather than the importance of the document to the progression of an appeal, which
they're
is what
all
the EAT
important
wrongly
to the
focused on.
instituting an appeal. By definition, they're all important. That the rule maker has said you must. These are the key documents you need to put in. So they're all important to the institution of the appeal.
As categories.
Sorry?
As categories, yes.
The more I'm thinking about this, the more I think you really there's two situations which are really rather different from each other. One is where you omit one of the documents altogether. There aren't very many now under the new rule. And that would be hard to say, probably wasn't major. More than minor anyway. And the other is where you leave out a part of a document. So if you include, say, the Employment Tribunal's reasons, but you leave off the last 5 pages, which are actually where they give their dispositive reasoning, you'd say that's crucially important. You know, that's what the whole case is about. But it would be a minor error in terms of, anyone would say it was a minor error. The photocopier stopped and you hadn't noticed, or
Or there may be.
It's a minor degree of compliance that you'd simply say, I put in the reasons, but a few pages were left out. Or what sometimes happens, you photocopy every other page because it doesn't do two-sided copy. Or
Exactly.
those sorts of things are just the sorts of things that are likely to happen. In one sense, that's very important. You can't make any sense of the reasons if you only read every other page. And yet, you, I think, would still say, you don't have to take a position on this, it's not your case. You would still say, look, there's been substantial compliance here. There was just a there was just a photocopying mix up and only every other page got copied.
Yes.
Because importance doesn't really matter because it's been rectified.
Yes. But whether or not it's been rectified, the error may still be minor, because although it is a requirement of the rule that a document of a particular description, say the employer's response, should be submitted, when one actually looks at the content of the document in a particular case, it may be so general and vacuous and that it's not actually remotely
I suppose so, but
important.
it's odd. This is meant to be a simple threshold test. The idea that the registrar is going to have to look at the document and form a view as to whether the pages missing were key or so vague they wouldn't help anyway. That's just not the kind of exercise it's supposed to be. I mean, I'm attracted by the cleanness of your test about the degree of compliance, which is simply how much was left out.
Yes,
I mean, I'm not sure the importance one helps you particularly, because if it is important, I'd have thought the terms of the grounds of resistance were pretty important.
I always come back to the fact that a minor error is subject to rectification and justice, capable of leading to an extension of time. That the minor requirement is the first element, and that therefore a judgment does need to be made as to whether the error once identified is a minor error
certainly.
or not.
But the question is what considerations go into deciding whether it's minor. I'm just questioning, because it may not be important in this case, or it might be, but certainly may be important in other cases if we're going to lay down a general approach, whether the degree of importance of the error, in the sense of actually looking at the page and seeing whether it said anything that mattered to the case, is really relevant.
What is essentially relevant is the degree of compliance.
Okay, anyway, but
and obviously the application of all of this may differ according to whether the missing document is the notice of appeal.
Yeah.
Or any of the other documents.
But nearly, as I think I said earlier, in practice, most of these cases are going to be part cases, especially now. It's true. Yours is in one sense a part, but it's a part which involves leaving out a crucial subordinate part of the document required. So it's quite a big part, but it's still a part case. The documents prescribed in 37.1 are simply the grounds of resistance. I keep saying 37.1, you know, I mean 3.1. It's simply the ground is simply the ET3, or the response, I think, the employer's response, whatever the technical term is, which you put in, but you didn't put in the meat of it, which happened to be in the form of a separate document. Anyway, there we are. I'm going over all ground. It's just me thinking aloud, which probably isn't helpful.
Because there are obviously different types of document in Rule 3.1. There's the documents created for the appeal, and there are the supporting documents that assist in understanding the appeal. The document created for the appeal is the notice of appeal. That obviously is the most crucial document for instituting an appeal because it sets out the grounds of appeal. So one can see that it's a substantial error not to submit that document in time. And if appellants were allowed more time to formulate their grounds of appeal, then they would gain an advantage in failing to comply with the Rule 3 time limit. But in contrast, and this is what's important for the purpose of this case, the other documents that have to be submitted when constituting an appeal exist whether or not an appeal is ever brought. For example, the pleadings and the decision being appealed. So, yes, likely to be a substantial error in not submitting the notice of appeal. Maybe a substantial error when the notice of appeal is submitted with none of the supporting documents, because then there is what can well be characterized as not substantial compliant. But another matter where it's a single document or part of a document or parts of a document, and obviously turning on the specific facts of the particular case. And in our submission, failure to submit grounds of resistance, the sole failure here, is quite simply, undoubtedly, a minor error, which required therefore to be rectified and was rectified, and rectified very promptly. So that's what it essentially comes to on ground one. Save that there is, as the court is aware, a number of EAT cases, both before and since Melki, which are referred to in particular in the respondent's skeleton. Lord, given that we're in the Court of Appeal, it may be that the court is not going to be assisted by my going through each and every one of these.
Certainly my view. Yeah.
So our conclusion on ground one is that our construction, first of all, accords with the language of Rule 37.5 and how minor error is described. Secondly, accords with a better understanding of the purpose of the word minor when considered in relation to the purpose of the provision as a whole, which is to promote substantial compliance with 3.1 while introducing a level of flexibility to ensure appeals can be progressed when the errors have been quickly rectified and it is just to allow an extension of time. And thirdly, our construction addresses the mischief the rule was introduced to address, as explained in the consultation report, the difficulty that potential appellants find in complying with the requirement to lodge all the required documents within the time limit. A construction that found that this failure was a substantial error cannot have been what was intended by the rules. So that's what we say on ground one. Very briefly, or much more briefly, at least on grounds 2 and 3. Ground 2 flows from ground 1. We submit that as Mr. Melki substantially, albeit not fully, complied with the documents required to institute an appeal, his error is properly characterized as minor. It's an error really indistinguishable from the error of the appellants in the Ridley case. And for the same reasons as in Ridley, we submit that Mr. Melki substantially complied with the Rule 3.1 requirements, and his error in not fully complying was indeed a minor one. We take issue with the proposition that a failure to provide a required document cannot be a minor error, and we've made our submissions in relation to that. And here, the key point is the error did not concern the notice of appeal. And because all the other supporting documents were submitted, albeit in one case slightly out of time, the requirements were substantially complied with and the error was minor, was capable of being rectified, was rectified, and that enables justice to be done in the case. Law ground 3 is the Rule 37(1) alternative, where the law was very much clarified by this court in Ridley since the EAT decision in the Melki case. So the EAT did not have the benefit of Ridley when it made its decision. But with the benefit of that hindsight, we submit that the EAT erred in the ways identified by this court in Ridley, because first, the EAT failed to recognize the distinction between the case of an appellant who lodges a notice of appeal and nearly all the required documents inside the time limit, and an appellant who lodges nothing until after the time limit. And I'll come in a moment to the relevant paragraph in Ridley on that. Secondly, the EAT erred in finding the appellant's explanation did not amount to a sufficient reason which could justify the extension of time, again looking at with Ridley. Ridley makes clear that when the reason for invoking the Rule 37(1) discretion is that the appellant has made a mistake, it's important for the EAT to consider how promptly the appellant corrects the error when it is brought to its attention. And that was a factor, an important factor, that the EAT failed to consider in this case. That the EAT was in error in asking whether there were exceptional circumstances in the present case. We say that was inappropriate and wrong, and that therefore we are able in the alternative to succeed on Rule 37(1) if necessary, with this case of unintentional and mistaken omission. That the points that are important from all the authorities that resound in Mr. Welke's favour are that the error was a genuine mistake by a litigant in person about what was required to institute an appeal. He took the initiative to follow that up with the EAT only 6 days later about whether his appeal had been received. And thirdly, he was then notified of the error and corrected it that very day, so only 6 days after the error had occurred. Ridley is in the bundle of authorities at tab 7 in the Industrial Relations Law Report. And one sees at paragraph 6 of the judgment. In short, we have concluded that all 3 appeals should be allowed. We, of course, accept the broad proposition by which this court is bound that the EAT is entitled to enforce the time limit strictly. We nevertheless consider first that in considering this type of case, in which an appellant has lodged an appeal within the time limit, but has failed to submit a document or part of a document which is required by 3(1), the EAT in these cases failed to take into account a factor which is relevant to the exercise of the Rule 37(1) discretion. That is, that the appellant had substantially complied with Rule 3(1) within the time limit. Second, we accept the submission that the broad power to extend time has become encrusted by authority in a way which has led to the emergence of rigid sub-rules which are not justified by the broad terms of 37(1) or by the reasoning in the important relevant cases. As a result, some judges have tended to rely on those sub-rules for automatic answers, rather than to consider the exercise of the discretion afresh in each case by looking closely at the facts of each case and not relying on generalizations. We would allow the appeals on those three grounds. And then much later in the judgment, at 140, I think paragraph 124 is worth looking at. It refers to a case of, well, paragraphs 123 and 124 refer to a case of Kostrova. That was one where the grounds of resistance were missing until she was informed of the situation. And so her error was that she mistakenly believed she submitted all she needed to submit. Essentially, the argument that the respondent seeks to deploy here was put forward there, and the Court of Appeal in Ridley held, as one will see a little later at paragraph 163, that the judge was in error in holding that a mistake could not be a good reason for being out of time. And then the main discussion begins from paragraph 143. And paragraph 144 is a very important paragraph in our submission. We conclude that the exercise of the discretion involves recognizing a material distinction. There is a legally significant difference between the case of an appellant who lodges a notice of appeal and nearly all the documents inside the time limit, and an appellant who lodges nothing until after the time limit has passed. The first such appellant has not fully met the requirements of Rule 3.1, but has nevertheless substantially complied with them. How substantially depends on what document or documents is or are missing, how much of any document is missing, and how important the document is to the appeal. That appellant has also, on the face of it, complied with the time limit in Rule 3.3. That difference is obviously material to the exercise of the discretion to extend time. Follows that that difference should in principle be reflected in the EAT's approach to the exercise of its power to extend time. We accept that the authorities about cases in which documents were missing do not refer to this distinction, and it follows do not consider it whether or not it is material to the exercise of discretion. But we see nothing in the reported decisions in this court to suggest that we're wrong to hold that the distinction we have identified is material to the exercise of the discretion. The express recognition of the importance.
I should have stopped you. I mean, if you read long passages, it's easier for us to read them to ourselves. How much more do you want us to read?
My Lord, I was going to refer to the first part of paragraph 145.
Down to the word rubric, or?
Yes.
Yeah, okay.
And then also paragraph 147.
Yes. Well, we'll read that.
And my Lord, then I think I referred to Kostrova, and that is picked up at paragraph 16.
Well, let's just read 147, and then you can take us to something else.
And I should also, my lord, have referred to paragraph 152.
Yeah. Just to the part sidelined or to the whole thing?
Just the, yes. But perhaps just a little above in Roman 2, the last part there, in other words, an appellant does not always have to show a good excuse for a delay in order to get an extension of time, and then the bit that is sidelined.
Yes, well, we read those. And what 162 you're about to take us to?
63. It's under the heading at 162 Kostrova. I referred to that a short while ago.
Yep.
So, Lord, our submission is that on a proper application of this court's judgment in Ridley, Mr. Melki's appeal should succeed if necessary under Rule 37.1.
Yes.
But whether it's 37.1 or 37.5 or both, this appeal should be allowed.
Thank you very much indeed, Mr. Gowdy. Yes, Mr. Kelly.
My lords, my lady, on ground 1, I have 4 submissions.
Yes.
The first is that the EAT correctly construed the term minor error in Rule 37.5. Second is that it correctly applied that term in the context of EAT proceedings, including by providing guidance, which can be summarized as focusing on the importance of the error to the proper progress of the appeal. Within that, I'll deal with my learned friend's approach. The third is that the EAT's approach is consistent with the link between the requirement in Rule 3.1 to provide documents or explanations for their absence, with the requirement in the overriding objective for the parties to assist the EAT. And finally, the EAT was correct to conclude the appellant's error was not minor.
Right.
I can start with what the EAT did say about minor error in paragraph 35. Page 41 of the core bundle.
Yep.
I appreciate what your lordship said earlier about the danger of glossing the words. But it's important to read this paragraph as a whole. It is not limiting the word minor to negligible errors. It also contrasts them with errors which are not serious or substantial. And beyond that, something that is comparatively unimportant. So I agree this should not be taken as a redefinition, but the EAT is not there saying the only errors it would consider as minor are ones that are negligible, perhaps in the sense that they could be ignored, as you said. And we said that's all consistent with the ordinary English language meaning of the word minor, and there's nothing in Rule 37.5 that compels you to a different meaning. Then the more significant submission is the correct approach, and whether it's degree of compliance or importance to the proper progress of the appeal. You've already looked at the paragraphs in which you can see this. There are various references in paragraphs 36 to 38, which embody this approach. We say my learned friend's approach on degree of compliance is wrong for 2 reasons. The first is that it doesn't give adequate consideration to why Rule 3 requires the appellant to lodge documents identified in that rule. And secondly, it doesn't reflect the approach that the EAT has taken in a number of other decisions to the function of Rule 3 and Rule 37.5. I'd like to pick up on 2 points that arose in the discussion between you and my learned friend. The first was that the correct approach obviously should be one which the registrar can apply, considering the documents that come in with the notice of appeal. And it should not have to involve a minute and detailed analysis of the importance of a particular page to a particular point in the appeal. But we say the guidance given by the EAT would allow the registrar to do just that. The second point that arose from discussion is the relevance of importance to the workability of my learned friend's approach and degree of compliance. What I think seemed to emerge is that if part of a document was missing, that would not be a minor error. There had been some compliance attempted with Rule 3.1 and Rule 3.7, at least the threshold had been crossed. The example he gave was that the omission of the notice of appeal in its entirety would not be a minor error because that's the document that institutes the appeal. However, an analogy to the present situation would be where the notice of appeal says within it, for grounds, please see attached grounds of appeal. But if you omitted that attached grounds of appeal document, on a friend's approach, you would have complied to a degree with the requirement of Rule 3.1. But
I actually understand Mr. Gowdy to be saying that, but I may have, you probably were listening more carefully than I was, but
Mr. Gowdy will say in his reply, I'm sure. But he has conceded importance as well.
His fundamental point would be that there's a distinction between the importance of the appellant's notice and grounds, on the one hand, as a document generated specifically for the purpose of the appeal, and other documents which merely show the history of the case, and therefore by definition pre-existed. That I thought was the only point he was making, but I could be wrong. But anyway, you say it doesn't make sense to distinguish between not serving an appellant's notice at all and serving one which doesn't include the crucial point, which is the grounds of appeal.
Yes.
Yes,
the more relevant point may be that once you can see that importance is relevant to whether or not an error is minor, you are at least halfway to agreeing with the approach the EAT has taken. Because the question is, important to what? And this is the point we make about the appellant not being sufficiently curious about why documents are set out in Rule 3.1. They're not listed there for any purpose other than that the EAT requires them for its own functions and procedures. So simply asking to what extent has a document been provided that is listed in Rule 3.1 doesn't take you far enough, because Rule 3.1 must have a purpose, and it must be to assist the EAT in progressing its appeals. So we say for that reason, the approach taken by the EAT here is preferable to the one Malone and Friend takes, where you're simply looking at a list of documents and seeing, has some of the list been provided? We say that isn't a satisfactory approach when the rule is meant to achieve something more than that.
It's going to be a very rare case now, marginally less so, at the time that this appeal was instituted, where no document of the kinds required is lodged at all.
Yes.
Appellant's notice, very odd. Judgment and reasons, pretty odd. What else? That's it, isn't it? What have you actually got to lodge now?
That is it.
That is it. So for the future, we're nearly all going to be dealing with partial omission cases. And I suppose you can subdivide those into this particular class of case, which will happen, where the document specified by the rules actually comes in two bits, the form and some attachment, and the attachment is left off.
Yes.
Or, as happened in Jocasta slightly unusually, the judgment and the reasons were supplied but not the judgment. So that's one subclass, and the other subclass is just missing pages, which again can be fairly extreme. My example of copying alternate pages, or simply leaving out a page or two. I'm not I'm thinking aloud, but any observations on that? It'd be quite helpful, wouldn't it, if we were going to write an essay about this, which it remains to be seen whether we do, for us to distinguish between those types of case.
Yes, my lord, it would. And in the example you put to my learned friend, where every second page has been photocopied, or the last 5 pages, the dispositive section of the reasons aren't present, we'd say that can't be a minor error. And that's consistent with what the EAT has said, but not consistent with the degree of compliance approach my learned friend invites you to adopt. The second half of what I wanted to say under this heading was largely to refer you to the authorities listed in my skeleton argument, where subsequent constitutions of the EAT have adopted what we say is a similar approach, focusing on the relevance of the proper progress of the appeal. I've heard what your lordship said a few moments ago about how much you want to hear about this, so unless you would like me to take you to it, I'm going to rely on paragraph 38 of my skeleton.
Yes.
Save for showing you one point, which answers a question that Milady raised earlier.
Which
About
paragraph
this-
in your skeleton do you want to just?
Paragraph 38, my lord.
Thank you. Oh, that's right.
And there was a point Milady asked earlier about what one could infer from the fact that the changes in the rules have deleted the requirement in little b to serve pleadings, the response and the claim. And the answer to that can be found in Akibe, in the authorities. It starts in tab 11. The pagination is 164. If it's electronic, it'll be 165. Decision of Mrs. Justice Eady. The facts aren't relevant. I just want to take you to one passage, which is paragraph 69.
Sorry, I've fallen behind. What page did you say in the bundle? Hard copy.
Begins on page 164, hard copy.
Thank you. Yeah, and the passage is at.
69, page 192, hard copy.
Thank you.
And if I could invite you to read paragraph 69 to yourself, and noting in particular the third sentence.
Yes. Yes, this is a 37-1 case.
Yes. Simply look at it for a matter of history, because what it makes clear is that the EAT can now access the ET systems and obtain the pleadings itself. So although my learned friend didn't say it, if anyone would suggest that the deletion of little b means the EAT was effectively conceding this isn't particularly important for us and the omission of the document is not a minor error, the answer to that is that part of the reason for the deletion of little b was that they can now go obtain those documents without relying on the parties to produce them. And if I could deal then with a number of points made in the appellant's skeleton argument. Starting at paragraph 38(1). Page 116 of the core bundle.
Yes.
Where the EAT is accused of engaging in circular reasoning, saying that, well, if this document is required by Rule 3.1, then surely it must always be non-minor to omit it. The EAT has given examples of where there could be omissions which are non-minor. Paragraph 38 and 37 of the EAT's decision. For instance, looking at the first sentence of paragraph 37, page 42 of the core bundle, where it talks about omitting one page. Sorry, the second sentence.
So can I just have that submission again?
So paragraph 38(1) accuses
Yes.
the EAT of engaging in circular reasoning
Yes.
and seems to suggest that there is no scope left for a minor error, saying that the errors will by their nature, if left unaddressed, impact on the progression of the appeal.
Yeah.
But of course, the EAT has given examples of a situation where there'll be a document which is required by the rule, not all of which is provided, but which it would say is not a minor error because it would
Yes,
not.
I see. Thank you. And what was the reference for where those examples are given?
Paragraph 37 of the EAT's decision, second sentence. And then also paragraph 38, the final two sentences, where it gives examples of where, for instance, the ACAS early conciliation information may not be relevant.
Yes. Where in 3.1, I've got a bit of a muddle about this.
But if it's the number, it would come in the claim form. ACAS early conciliation would have to come in the claim form.
Oh, I see.
So if you left off the first page of the claim form where the number features, or it could be the second page, I can't recall, you could have a minor error, which the EAT here would say can be forgiven. The next point is paragraph 38(2)(a) of the appellant skeleton, page 116 over to 117 of the core bundle, where it says it's difficult to see why negligible errors require rectification. Now, I've already pointed out it's not just negligible errors, but the short answer to that is if the rules tell you to produce a document, you should produce the document. It's simply a matter of respect. Before you crave the indulgence of the EAT and asking for an extension of time, you should do what you've been told to do, even if it is a minor error. Then 38(2)(b) on page 117 says that it might be a minor error because it has been rectified quickly. We say that's eliding the different stages you have to go through in Rule 37.5. Earlier, well, we did describe it in 3 stages. There are 2 requirements, minor and rectification, and then you come to the discretion.
Yeah.
So rectification has been separated out by the statute
Yes, very quite.
away from minorness. And just for reference, you can see that approach in JASIM paragraph 22, which is authorities 51 of the pagination. And the same approach
(22), did you say?
22, which is, I'm
This
sorry,
is Judge Auerbach.
Yeah, so after it starts, and actually the passage is at 60 of the pagination.
Yeah.
Breaking it down to 3 stages, we said that's the correct approach. It's also the approach
Yeah.
you described.
Yeah.
So rectification isn't relevant to minorness. And you'll find the same approach applied by Mrs. Justice Eady in AB. And that's page, the passage is 137.
Well, really, this is common ground. I mean, you don't even need authority for it. You just have to
No.
read the rule. That's obviously how it works. Yeah.
Then the next point is paragraph 38(3) of the appellant skeleton and 117 of the core bundle, where it queries how a negligible error could prejudice a respondent. Now, as I pointed out, it's not just negligible errors, but we say you should be very cautious about trying to answer this question. Because at this third stage of Rule 37.5, you have to consider all the circumstances of the case. And you shouldn't try to answer now in the abstract and say that it is not possible for a negligible error to cause prejudice to the respondent. It may be that the circumstances arise in which there is prejudice.
It is odd, though. It is quite difficult to think of an error which was minor, whatever meaning you give to that, and has been rectified, and in practice has been promptly rectified, because that's one of the factors you've got to have a look at anyway, and yet it still causes prejudice. I don't say it's impossible, and I think the rule maker was sensible to build it in, because you never know. But it's not going to be the prejudice. If all the other boxes are ticked, it's going to be hard to imagine prejudice. I do accept that as a comment.
I do. One could imagine unlikely but possible hypotheticals.
Yeah.
So if there is a dispute about what the evidence was at a hearing, and in the gap between the appeal being incorrectly submitted and it being rectified, for whatever reason, the employment tribunal judge retires and destroys his notes,
Yeah.
then that delay, the gap between lodging and rectification, has caused prejudice.
Yes. Thank you.
There are other variations you could create on that, but it's possible.
I'm not quite clear what your submission is about negligibility. I may have missed it.
Simply that
does that have any role to play in this?
Simply that the appellant keeps characterising what the EAT said as referring only to negligible errors, and that is not what was said in paragraph 35. It was one of the descriptions given.
Negligible or? But what does negligible, is negligibility of any relevance in determining whether an error is minor?
It may be, but is not exclusively what the word minor may mean. So it may be relevant, it may not be relevant.
Would it be fair to say that all negligible errors will by definition be minor?
I accept that's likely.
So what is the benefit from considering the negligibility of an error?
Well, it may inform whether it's minor, but it's not useful to substitute it for the word minor.
You were really, as I said earlier, disavowing negligibility. It's not part of your test, and you say it wasn't really part of the EET's either.
Precisely. One should not use that. One shouldn't read the ET as substituting for the word minor at the word negligible.
Well,
because that's only part of what it said in paragraph 35.
You're correct. But does his use of the word negligibility have any other relevance in assessing whether he was correct in his analysis?
There's one way of looking at paragraph 35 was to say it's a bit of a muddle. Because minor, comparatively unimportant, maybe we disagree with that. Contrast with serious or substantial, maybe we disagree with that. But then there's an element of confusion introduced potentially by the second sentence. Rule 37B is designed for errors which are negligible or of no real importance to the topic of errors. So one way of reading that paragraph is that the EAT thought that the second sentence was a summary, an accurate summary of the first two sentences, and I'm not sure that's right.
I don't think that's what it is saying, but it brings me back to a point you raised earlier, milady, which is you said that minor was, I think, a relative adjective.
Yeah.
And of course, it must be minor in relation to something.
Yeah.
And we say it's correct here to identify the proper progress of the appeal as the thing it must be minor in relation to.
Well, I think, well, or it could be said it's just it's a minor error as contrasted with a major error.
Yes, but of course, a mouse is minor in contrast with an elephant, but major in contrast with an atom. So I think minor and major on their own don't tell you enough.
But the point is it's used to qualify the word error.
Well, that would just take it back to the point I made that if it's an error, the error is failing to include the documents in 3.1, and there is a purpose to those documents being required, and it goes to the proper progress of the appeal.
This may be a point just to ask you what I asked Mr. Gowdy. Does the question of excusability feed into whether the error is minor or major?
No, that is the third stage.
It comes in, yeah.
And to an extent, the second stage, because rectification is part of the excuse.
I hesitate, obviously, given our respective experience in the field, to criticise the judge here. But do you think we could excise our negligible from paragraph 35 and to get the real meaning of what he was saying?
Yes, negligible is going to be a subset of minor, but it doesn't exhaust the meaning of minor, so you could happily
You
cut it
wouldn't
out.
you wouldn't get anywhere, would you, by really in resolving whether an error was minor by looking to see whether it was negligible? Doesn't add anything.
No,
Did you pick it up from another case of no real importance? I think, isn't that one of the things he took from an earlier decision of Judge Auerbach on 37.1? Maybe not.
well,
The concept of the progress of the case, I think, certainly did come from an earlier case, didn't it?
yes, that was Angle.
Angle, that's right. Does he quote from Angle?
It does. So it's paragraph 38 of the judgment. Said that the grounds of claim or resistance, though in fact resistance is not mentioned in the judgment, are essential documents. They set out the substance of the claim and the defence, to which it is likely to be essential in understanding the decision appealed. So those last few words are an example of this
Yes.
proper progress of the appeal approach, and says, I agree. You will find Angle in the authorities starting at 23.
Yes.
Combination. But the passage being referred to is on page starting at 32. It's paragraph 28. In this case, box 8.2 of the claim form referred the reader to the attached.
Sorry,
grounds of
which
claim.
paragraph did you say?
Paragraph 28, which is the very bottom of page 32. And it's the first
Yes.
3 sentences.
Yes. So, in fact, the general concept of important to the progress of the case. Oh, no. Well, that is, I may have just misremembered. I didn't think that it was the judge in this case who first used the formula about the formula about of no real importance to the proper progress of an appeal. I thought that came from somewhere else, but maybe it doesn't. No, I thought it came from
At this
Angle.
point, I'm going to have to confess my ignorance because I don't.
Well,
recall
it
that
certainly won't have come from any document that. I wonder if it came from Fincham.
I can tell you I can't take credit for it because our submissions in the EAT spent a lot of time focusing on the point about the transitional provisions and whether they applied. And then my submission was very brief. It was to say, well, look at what has been said in Angle about the importance of grounds of claim. The same must be true for grounds of resistance.
Yep.
There we go. So I don't think I gave Mr. Burns any great inspiration. So I can't claim any credit for his
Well, okay,
approach.
this sort of archaeology perhaps doesn't matter very much, except that we were just it is an important paragraph because it's effectively his self-direction. So anything we can see about how he got to it is worth doing. But the answer is, although both my lady and I thought we had seen it in one of the other earlier cases, neither of us can find it, and it may be wrong. Thank you.
I have 2 other brief points on this, and then my other 2 headings underground one are very short, but it's back to the appellant skeleton argument.
Yeah.
Paragraph 44 sub 1, which you'll find on page 118 over to 119 of the core bundle. And it says that the construction here is too narrow. The construction of 37.5 means that, in effect, it gives you no more than what 37.1 already did. And it cites two examples, Fincham and Shah. And the point to make about this, of course, is that those were decisions under 37.1 when exceptional circumstances would have been required for an extension of time to have been granted. That would not be the case under Rule 37.5. So there would be a meaningful difference in any event. Jassim is an example of the EAT deciding that it would have extended time, or did extend time under 37.5, but it would not under 37.1.
Yep.
I'll show you the final paragraphs of that, but Jassim begins on page 51 of the authorities. And this was an appeal against a decision affecting two claims, and the ET1 and ET3 for the first claim were not submitted.
Yes.
And the decision, the dispositive section, starts around paragraph 40, which is page 66 of the pagination. And if I could ask you to read paragraphs 40, 45, and 46, you'll see that you do get different outcomes depending on what rule is being applied.
Yes. I've seen that already. Yeah.
The point is they don't occupy completely the same ground. And then the final point in the skeleton argument is paragraph 48. Which is page 120 of the core bundle. And the appellant there makes the submission that because of the EAT's narrow construction of minor error, it is now Rule 37.1, which is the more forgiving rule. And it gives the examples of Hewer and AB. Both of those are post-Ridley cases. So applying Rule 37.1 after Ridley.
And are they both post the decision in this case?
Yes. Now, what we are all agreed on is that you can't interpret Rule 37.5 by reference to Rule 37.1 as it was understood once Ridley was decided. Is that post-date of the amendments? You see that in paragraph 46 of the appellant skeleton. You have to understand Rule 37 against the background of how Rule 37.1 power was understood to operate at the time. So it's not helpful to look at decisions based on a changed interpretation of Rule 37.1 and try to understand from them what Rule 37.5 was meant to mean. And the final two headings on ground one are quite short. The third one is the relevance of the obligation in the overriding objective to cooperate with the tribunal. I would like to look at the decision in Akibe, which starts on 164 of the pagination. This was an appeal against a decision where 7 decisions effectively were appealed. There have been 7 decisions made by the Employment Tribunal. The effect of 4 of them were appealed, but there was only an ET1 and ET3 submitted for one of those claims. And at paragraph 37, which you'll find on 178 of the pagination, here Mrs. Justice Eady is discussing the reason why there is an obligation in Rule 3.1 to explain why you are not submitting documents. And if I could invite you to read the paragraph and just note the sentence under the indented text, which creates the link to the overriding objective.
I'm so sorry, I didn't pick up the paragraph reference, it's my fault, Mr. Kelly.
Paragraph 37, milady, on page 178.
Thank you very much.
And in particular, the sentence under the indented text.
Yeah.
And the point we take from this is that that aspect of Rule 3.1, the obligation to explain why you're not submitting a document, is linked to that aspect of the overriding objective. Although it's not expressly dealt with there, we say the obligation to submit documents must similarly be linked to that aspect of the overriding objective. And that is consistent, that obligation to cooperate, with the cooperation with the
What does
tribunal.
this add? I mean, we're dealing with a mistake here, so it's not non-cooperation in the ordinary sense.
We say it's the idea of Rule 3.1 being linked with cooperation is consistent with trying to assist the EAT, and that is consistent with the purpose approach, the progression of the appeal approach rather than the degree of compliance approach.
Would you be offended if I described that as a make-weight submission?
I wouldn't. I don't place any huge weight on it. Then the fourth heading I've already dealt with, which is to say that given all of that, the appellant's error was not minor, and I've already shown you the passage in Angle and the decision of the EAT, so I don't need to say anything more about that. Then taking grounds 2 and 3 together, we agree the outcome is going to be the same under either heading, and the facts that are relevant are going to be the same. And if I can go quite quickly through Ridley, I don't expect you'll be assisted by many references given how well the panel knows it, but going straight to paragraph 147, which you'll find on 96 of the pagination.
Yes.
And within 147, it's about 8 lines down where it says an understandable or reasonable mistake about the documents cannot necessarily be discounted simply on the basis the litigant filed the papers earlier and so on. So we're happy to concede that our understandable or reasonable mistake may be a sufficient basis for extending time, but we say the mistake here is not understandable or reasonable. And before I leave, Ridley, picking up on a point you made earlier, my lady, which is that it is true that the tenor of the decisions is that litigants in person are treated the same as those who are professionally advised. I'm going to have 4 factual points, and that hopefully will conclude my submissions. The first is looking at the reason recorded by the EAT for not submitting the document. It's at paragraph 44, page 44 of the core bundle.
Have the reference again?
Page 44 of the core bundle, paragraph 44 of the judgment. And the claimant's explanation, as summarised by Mr. Gowdy's skeleton argument, is that he had included the other documents and was unaware that he was also required to include the respondent's grounds of resistance. And essentially that's it. If I can ask you then to look at the supplementary bundle. And page 44.
All 44s.
have on page 44 the letter to Mr. Melki enclosing the decision. And if you go over to page 45, and on page 45, look towards the end, there's a paragraph that says, there is further information about appealing to the Employment Appeals Tribunal here, and it gives you a link to leaflet T440. You'll find that starting on page 47. To pick out a few relevant passages. Starting on page 47, I want to appeal. This leaflet is for guidance only and should be read in conjunction with the Employment Appeal Tribunal practice direction, and then gives you a link. You can get copies of the practice direction forms and leaflet referred to in this leaflet by visiting, and it gives you a link. Over the page, 48, under the heading The Required Documents, please read section 1 to 4 of the practice direction and the practice statement before you're sending your appeal to the EAT. And then skipping down 3 more paragraphs, you must also send clean, unmarked copies of the following documents. If you omit any which are relevant, then you must include an explanation for why you did not send them. And the third bullet point is response ET3. And then please see paragraphs 3.1 to 3.4. And sorry, just as I remember it, because relevance is mentioned here, I agree with what your lordship said earlier. When relevant is used in Rule 37.5, it must mean the documents which are in 3.1, which are relevant to my appeal, which exist in the case of my appeal. It's not relevant to the substance of the arguments. But it specifically directs you to paragraphs 3.1 to 3.4 of the practice direction.
Bit odd. Meaning,
Yes.
copies of if you omit any which are relevant, well, these 3 will always be relevant, won't they?
They may not always exist. There may not be a response if no response was provided and you were getting default judgment, for instance, and you appealed on the question of quantum of
Yes,
that
I
default
see.
judgment.
No, fair point. Okay, sorry, carry on.
And then the final document to look at is the practice direction as then in force on page 57. And this is where, if the appellant followed what he was directed to do, he would have received clarity. So in paragraph 3.1, starting 7 lines down, it says, in addition, the appellant must provide copies of the Employment Tribunal's written reasons, together with a copy of the claim, the Form ET1 and any attached grounds, and the response, the Form ET3 and any attached grounds.
Yeah.
He said there's been no explanation for why, having been given that guidance, the appellant didn't follow it. And that is not a good or understandable reason. And the last point I need to make is to draw a contrast with the example that my learned friend gave you within Ridley. He referred you to paragraph 153. Sorry, 163. Which was the example of Ms. Kostrova. And that's on page 98 of the pagination. And just one point of distinction I want to highlight is in paragraph 163, Roman numeral 4, the mention of Ms. Kostrova was under stress and suffering from medical issues. I fail to appreciate that. There is no information here at all about why Mr. Melki made the mistake he did. He simply says, I made a mistake. And we accept a good or understandable reason might be sufficient to extend time, but he has not provided one. My Lord, unless I can assist you, that's all I propose to say.
No, thank you very much indeed, Mr. Kelly. That was very helpful and succinct. Yes, Mr. Gowdy.
Lord, very briefly in reply, trying to avoid repeating what I have previously said. In our submission, whether one is looking at the literal requirements of either limb of Rule 37 or at their purpose, the key point is that the purpose of the minor requirement is that it promotes substantial compliance with the rules, whilst at the same time allowing flexibility where there has not been absolute compliance. And in that setting, the requirement here was a minor requirement. And secondly, not only was it a minor requirement, but it was also in the, not only was the error minor, but it was also an unintentional and mistaken omission, which was understandable. Lord, beyond that, I think I would be repeating what I've said in opening.
Thank you very much indeed. We're grateful to both counsel for clear and succinct submissions. We clearly need to give this decision particular thought, since it's the first one of this court on 37.5, so we will be reserving our decision. Judgments will be circulated in draft in the usual way for the correction of typographical and other minor factual errors, and so the parties can agree the terms of any consequential order. The circulation is, of course, only for those purposes, and that constrains who it may be circulated to beyond the parties themselves. And if there's any breach of the confidentiality, whoever is responsible can get into serious trouble, but you don't need to be told that. Thank you very much.
Lord, may I just have a moment to check one thing with...
Yes, certainly.
with Martin?
I'm just interested how big it is.
Yes, it's a single assignment. Yes.
I think it's a point that I have made recently by reference to the judgment in Ridley, that as to what is needed in order for Rule 37.1 to be applicable. But Lord, I don't seek to elaborate upon that further at this stage.
Yes, thank you. We would be grateful if you could send really two things. One, Rule 37.1 as it stood at the relevant time for the institution of the appeal. I know we can find it in the judgment in Ridley, but I think we just like to see it, as it were, in the Queen's printer's copy, be quite sure we got it right.
Yes.
I say the Queen's printer's copy, we can have it off the internet if that's easier, but we want the official version. And secondly, the statutory instrument by which the rules were changed, which will include both the changes to Rule 37. So I keep saying 37.1, you know I mean 3.1, it's just
Yes.
a slip. Both the changes to Rule 3.1 and to Rule 37, which happened in the same statutory instrument in 2023, I think. Anyway, that one.
Yes.
If that could just be sent to our clerks, or one of our clerks, you must have a reference for at least one. Thank you very much indeed. Thank you. Your client wants to say something to you, Mr. Gowdy, just before we rise.
Am I okay to speak for 1 minute?
If you wish to speak directly to the court, I honestly don't think that's necessary. The case has been very well presented by your legal team. If there is some point you want to make, Mr. Gowdy, just have a word with your client for a moment and see whether it's something that you ought to make on his behalf.
Like I mentioned, I'll leave like I mentioned to Oliver, the EAT put me in a lengthy process for 2 years. I had no legal support. And then a judge came and did confirm to them there are sufficient merits about them and they are losers, but didn't give me hearing. I don't know why. They are cheating party, it's highly clear.
Nothing to add,
No,
my
no,
lord.
correct.
Thank you very much for the opportunity.
Rise.